All right, imagine this for a second. You're this, like, successful Victorian-era contractor, right? And you land this huge project to rebuild a major London bridge. Sounds pretty awesome, right?
Oh yeah, definitely a dream project.
Yeah, so you follow these plans. They gave you super detailed, meticulously detailed plans given to ya by the city, but then, like, disaster strikes.
Oh.
Yeah. So this innovative technology, they insisted on using it, just totally fails. And now you're just, like, left with these massive delays, and the costs are just, like, soaring through the roof.
That's every contractor's nightmare.
Oh, yeah. So what happens next? Well, that's exactly what we're going to be looking at today. We're diving deep into this really fascinating legal case from 1876.
Okay, I'm intrigued.
Yeah, and it involves this guy, Alexander Thorn, who is the contractor for the Blackfriars Bridge reconstruction and, of course, the City of London.
Oh, so this is going to be juicy.
Oh, yeah. So this case, it really gives us some interesting insights, I think, into just how complex these construction contracts can be and all the legal principles that govern them, especially when they're using these innovative or untested designs.
Yeah, that's where things get really tricky.
Oh, yeah, for sure. And get this, our primary source is the actual legal document.
Wow, so we're going straight to the source.
Oh, yeah, from the court case. I know legal documents don't always sound super thrilling, but trust me, this one is a page-turner.
All right, I'll take your word for it.
Yeah, it's got all these twists and turns, and it really raises questions about, responsibility and risk and the challenges that come with, like, pushing these technological boundaries. And that stuff is still relevant even today,
Yeah, for sure, history often repeats itself.
Oh, for sure. So let's set the scene, okay? It's 1876. London's bustling, as always. And the Blackfriars Bridge is in desperate need of an upgrade.
Makes sense, things need maintenance.
Oh, yeah, big time. And so the Corporation of London, they put out this call for tenders, which is basically like, inviting contractors to bid on the project.
Okay, so like a competition to see who can do it best.
Exactly. And they already had a plan, all set designed by their engineer, this guy, Mr. Cubitt. And it involved using this relatively new technology called iron caissons.
Iron caissons. Okay, I'm not familiar with those. What are they exactly?
Yeah, so these caissons were these huge iron structures. Think of them like giant upside-down boxes, and they'd be sunk into the riverbed to make the foundations for the bridge piers.
Oh, wow. So like the base of the support columns.
Exactly. It was a pretty big change from the traditional method they were using before, which was timber cofferdams, which are basically these temporary enclosures they build in the water so they can work below the water line.
I see. So this was a pretty big shift in technology.
Oh, yeah. Big time. So then enters Alexander Thorn and his brother, these seasoned contractors,
A bit around the block.
Oh, yeah. And they saw this as an opportunity to, like, make their mark on London's skyline, you know?
I mean, who wouldn't want to be the one to rebuild Blackfriars Bridge?
Totally. So they submitted their bid, won the contract, and signed this legally binding agreement with the city. And like any good contract, this one had a super detailed specification, outlining everything that needed to be done, how it should be done, and what materials to use.
Right. So everything's crystal clear. No room for misinterpretations.
Exactly. And you can bet that those iron caissons, they were front and center in those specs.
They were the stars of the show.
Absolutely. And here's where things start to get really interesting. So the specification, it had clauses that said certain parts of the project, like the exact depth of the riverbed, that wasn't guaranteed.
Okay, so they were acknowledging that there might be some unknowns.
Exactly, but there was no explicit warranty. No like ironclad promise that the caissons themselves would actually work the way they were supposed to.
Oh, wow. So no guarantees on the core technology. That's a bit risky.
Yeah, and now you might be thinking, well, why wouldn't they explicitly guarantee that, for such a crucial part of the project? And it's important to remember this was a time of, like, super rapid technological advancement, and sometimes, like, the legal stuff just couldn't keep up,
Yeah, the laws couldn't quite catch up with the engineering.
Exactly. And plus, who wants to bet against this shiny new piece of engineering? Everyone's probably thinking this is going to be amazing.
It's easy to get caught up in the excitement of new technology.
Oh, totally. But we all know sometimes even the best laid plans, they can go totally wrong.
Oh, yeah. Murphy's Law, right?
Right. So construction gets underway. They build these caissons to Mr. Cubitt's exact specifications. They lower them down into the Thames and, well, they fail.
Oh, no. What went wrong?
Well, it turns out the caissons, for all their supposed innovation, they just couldn't handle the powerful currents of the river.
So the river was stronger than their fancy new technology.
Sadly, yeah. And this wasn't just some minor hiccup. This was like a major setback.
Oh, I can imagine. So what did they do then?
Yeah.
The upper parts of the caissons, they had to be abandoned. Just imagine like all that frustration, the wasted time and resources.
Yeah, I bet that was a tough pill to swallow. What did they do?
Well, Thorn, he had to come up with a plan B.
Mm-hmm.
And that meant going back to a more like traditional method, which was tide work to finish those bridge piers.
Tide work, so they were basically like at the mercy of the river.
Exactly. It added a whole other layer of complexity to an already complicated project.
I bet, and I can only imagine what that did to the budget.
Oh, yeah. The financial implications were huge delays, meant more labor costs, material costs, just a ton of stress for everyone.
Yeah, that makes sense.
Yeah.
So at this point, Thorne's probably feeling like he got a raw deal. He followed the city's plans perfectly, and it turns out those plans were flawed. And now he's stuck with this half-built bridge and a mountain of unexpected expenses. What did he do? Well, he did what any smart contractor in a tough spot would do. He got himself a lawyer and sued the City of London.
So he took them to court. That's a bold move.
Oh, yeah, he was not messing around. So Thorne's argument was basically this: you gave me these super detailed plans. I was bound by the contract to follow them, and those plans turned out to be defective. So now I've got all these losses, and you should be responsible.
Seems pretty straightforward, right?
Yeah, on the surface it does, but legally it was a lot more complex. Remember, there was no explicit warranty about whether the caissons would actually work in the contract.
Right. So Thorne's legal team had to think outside the box.
Exactly. They argued that by putting in those specific disclaimers, the city was basically implicitly warranting everything else, including the caissons.
So it's like saying, we're not responsible if the paint color is a bit off, but you better believe this whole building's not going to just fall down.
Yeah, that's a great analogy. So they were trying to use the city's own attention to detail against them. Pretty clever.
It was a smart strategy, but what was the city's response? Did they admit they messed up?
Not a chance. Their defense was basically buyer beware. They said Thorn, as an experienced contractor, should have looked over those plans really carefully and figured out if they were going to work before he signed anything.
So they were shifting the blame back to Thorn.
Exactly. They pointed out that he had access to those plans from the start and could have said something. Then their argument was basically, you had your chance to spot any problems you didn't, and now you're trying to make us pay for your own mistake.
It sounds like a classic case of he said, she said. So who did the court side with?
Well, it wasn't just one court case, actually. It went through several appeals, and every single time the court sided with the City of London.
Wow. So even though Thorn followed the plans exactly, he was still on the hook for everything.
I know, it seems kind of harsh, right? Because it wasn't his design that failed.
Yeah, but the courts were sending a clear message about due diligence, especially when you're dealing with new and untested technology.
So they were basically saying contractors can't just blindly trust the plans they're given. They have to do their own homework and assess the risks themselves.
It's exactly.
Yeah.
It's a crucial lesson, especially for complex projects with innovative elements. You can't just assume everything will go perfectly, even if the plans come from a reputable source.
So due diligence, what does that actually look like in this case? What could Thorn have done differently to protect himself?
Well, he could have hired his own independent engineer to take a look at Mr. Cubitt's plans. They might have spotted the problems with the caissons and warned him about the risks.
That's a good point. So he basically put all his eggs in one basket.
In a way, yeah. He also could have tried to negotiate a clause in the contract that would share some of the risk with the city.
So like a clause that said if the caissons don't work, the city has to cover some of the extra costs.
Exactly. That would have given him some protection if things went south.
Makes sense. So even though the courts ruled in favor of the city, there were things Thorn could have done to reduce his risk from the beginning.
Absolutely. It's a cautionary tale for anyone involved in projects like this. Don't just assume everything will go according to plan, even if you're following someone else's blueprint.
Right. So we know the courts sided with the city and really emphasized the importance of due diligence. But did Thorn get any compensation at all for all the trouble he went through?
Well, the courts did mention another way he could have tried to get some of his money back, though it wasn't directly related to the caisson issue.
Oh, interesting. What was that?
They suggested that if Thorn thought he deserved to be paid for all that extra work because of the caisson's failing, he could have filed a quantum meruit claim.
Quantum meruit. Now we're getting into some serious legal jargon. Can you break that down for us regular folks?
Sure. Basically, quantum meruit means as much as he deserves. It's a legal principle that says someone should be paid a fair price for the services they provide, even if there's no official contract covering those specific services.
Ah, okay. So in Thorne's case, he could have argued that all the extra work he did because of those faulty caissons, that wasn't part of the original deal, and he should get paid extra for it.
Exactly. The courts weren't saying he would have definitely won that claim, but they were saying it was a valid legal option he could have pursued.
So it sounds like they were saying, look, we understand you were put in a tough spot, but you approached this from the wrong legal angle. There might be other ways to recover some of your losses.
That's a good summary, and it shows how important it is to understand these legal concepts, like implied warranty and quantum meruit. They can really make a difference in situations like this.
It's like having extra tools in your legal toolbox, right?
Precisely, the more you know, the better equipped you are to deal with these complex situations.
So this case isn't just about some old bridge. It's a reminder to be super careful with contracts. And it also makes you think about who's responsible when new technologies don't work out the way we expect.
It definitely raises some big questions that are still relevant today.
Absolutely. I mean,
Right.
think about all the innovations happening now. Self-driving cars, AI-powered infrastructure, space tourism. These are all things that push the boundaries of technology, and there's always some uncertainty about how they'll actually work in real life.
That's a great point. It makes you wonder how modern contracts deal with all these unknowns. I mean, back then it was iron caissons. Now it's algorithms, sensors, materials that haven't even been invented yet.
It's like Thorn and the City of London were the 19th century version of a tech startup, and their investors both betting on this groundbreaking idea, but not fully understanding the risks involved. So how do we handle these things in today's world?
Well, one big difference is that contracts today are way more complex and cover a lot more ground than they used to.
Makes sense, so they've gotten smarter over time.
Right. They often include things like force majeure clauses.
Yeah.
You know, those are the ones that say if something totally unexpected happens, like a natural disaster or a pandemic, the parties don't have to hold up their end of the bargain.
Oh, yeah. Those are important nowadays.
And they also tend to have these really detailed sections about risk assessment, where they try to think of everything that could go wrong and who's responsible if it does.
So it sounds like contracts have gotten better at anticipating problems and deciding who takes the hit if things go sideways. But even with all that, can't things still go wrong?
Of course, you can't plan for everything. There's always human error and unexpected glitches, and just the fact that innovation is, by definition, unpredictable.
So there's always going to be some level of risk no matter what.
Right. But the important lesson from Thorn's case is that even with a super detailed contract and cutting-edge technology, understanding and managing risk is something everyone has to be involved in.
So it's not just on the contractor or the client. They both have to work together.
Exactly. The client needs to be upfront about any experimental stuff they're using, and the contractor needs to do their due diligence, ask the tough questions, and make sure they're not biting off more than they can chew.
And this brings us back to that quantum meruit thing you were talking about earlier, right?
Exactly. Even with the most airtight contracts, there are going to be times when unexpected things happen and lead to extra work or expenses.
Like with those caissons?
Exactly. And understanding legal concepts like quantum merit gives people and businesses a way to ask for fair compensation when those things happen, even if it wasn't spelled out in the original contract.
So it's like a safety net in case things go off the rails.
You could say that it's a way to make sure everyone gets paid fairly for the work they do.
So as we wrap up our deep dive into this crazy bridge building saga, what are the key things you want our listeners to remember?
Well, first off, I think it's cool to see how history can give us valuable lessons for dealing with present-day challenges, even though the technology is totally different. The problems Thorn and the City of London faced are similar to the stuff we deal with today.
Yeah, that's a good point.
Secondly, it shows just how important due diligence, clear communication, and a shared understanding of risk are in any contract, especially when you're dealing with new technology.
Like we were talking about with self-driving cars and all that.
Yeah, exactly. And lastly, it reminds us that the legal world is constantly changing to keep up with new inventions and challenges. So knowing the key legal concepts can really help people and businesses protect themselves and navigate tricky situations.
Well said. And if I can add my 2 cents, I think this case shows that even when things go wrong, when you feel like you've been dealt a bad hand, there might be other legal options out there. Don't be afraid to get some expert advice and explore all your possibilities.
Couldn't agree more. Sometimes you just need a fresh perspective to see the bigger picture.
Exactly. So folks, remember, even when things get messy, there might be a way out. So stay curious and keep those legal brains sharp.
Words to live by.
Thanks for joining me on this deep dive into the world of Victorian bridges, legal battles, and legal concepts that are still relevant today. Until next time, stay curious and keep exploring.